Welcome to Employment Law This Week. I'm George Whipple. Big news out of the Supreme Court. In a major ruling last Thursday, the court rejected the broad standard that the NLRB has been advocating for preliminary injunctions under Section 10J. Epstein Becker Green, Steve Swirsky has more.
The Supreme Court's decision in the Starbucks case is going to have the effect of making it much more difficult for the NLRB to convince a federal court to grant a Section 10J injunction, meaning that an injunction to provide interim relief before the labor board has been able to establish in a hearing that an unfair labor practice actually was committed.
Under the Supreme Court's decision, when the board seeks a 10J injunction, it must establish the four elements that are traditionally required for a district court to grant an injunction: that the NLRB is likely to succeed on the merits, that there is irreparable harm if relief isn't granted, that the equities tip in favor of granting the injunction, and that the injunction is in the public interest.
I think that this is going to have a positive impact, obviously, for employers who are facing the prospect of the board seeking 10J injunctions against them. The General Counsel has made the increased use of Section 10J injunctive relief one of her priorities. She's been seeking injunctions in more cases, and particularly in cases with organizing, where it's her position that an unfair labor practice by an employer is intended to nip the organizing campaign in the bud. Because the standard has been recognized to be the higher four-factor test, it is not going to be as automatic, if you will, that a district court judge will defer to the position of the NLRB and its regional director as to whether an injunction should issue. This means that the use of injunctions is not going to be as readily available as the General Counsel, has indicated she would like.
Thanks, Steve, and thank you for watching. We'll see you next time.